Namaste, Ji, Namaste. Welcome to Courtroom. Hope you're doing well. So, the Supreme Court has delivered a landmark judgment on the 2nd of March. If you're preparing for CLAT PG or any LLM entrance exam or judiciary examinations, you need to take notes from this lecture. Secondly, if you are, let us say, preparing for a LLB entrance and are constantly wondering what to mark right to vote, for example, whether is it a statutory right or is it a constitutional right, the Supreme Court has traced the length and breadth of the right to vote in its 378-page judgment, which we are going to be discussing in about 5 minutes, and a brief summary of the judgment that is, and the endless U-turns that the Supreme Court has taken, that whether the right to vote is a constitutional right or a statutory right. They have finally, hopefully once and for all, clarified the situation, except that they just ended up not making the final pronouncement, but they have given the entire answer to you as to what to mark the right to vote as. So the judgment name is Anoop Baranwal versus Union of India. This now becomes a part of static GK for any future exam, whether it's the UPSC prelims, whatever it is. This judgment name will need to be remembered. तो सारा मुद्दा जो सारी जो problem जो आ रही है, that's under 324 clause 2. So that's article 324 clause 2. I'll just zoom it a little so that you can see it better. The election commission shall consist of the chief election commissioner, etc. I won't read out the entire article, but it says subject to the provisions of any law made in that behalf by parliament. Now this is that specific, you can say, phrase or line that has caused this judgment to be delivered. This is the main problem that existed and still exists. So the Supreme Court has tried to resolve this problem. So what is the problem? So if any, as the president may from time to time fix, and the appointment of the chief election commissioner and the other election commissioners shall, subject to the provisions of any law made in that behalf by parliament, यानी कि parliament दूसरा law enact करे या be made by the president. The president साहब subject to any law will make such appointments, and if your polity is decent enough, you will know that the president works on the aid and advice of the Council of Ministers, which is headed by the PM. Great work. So if the election commission, can we make the conclusion that the PM indirectly is controlling the election commission of India? That is what the contention of the petitioners was, because this line, subject to the provisions of any law made in that behalf by parliament till date has not made any law, and that is what was irking and disturbing the Supreme Court a little bit. So therefore they have delivered this judgment. So no law enacted yet. So net the PM was appointing your chief election commissioners till date, not specifically Modi ji, till date this was happening. Alright. So this writ petition was filed in January 2015 की writ petition है. It is not that it's common misconception कि अरुण गोयल की appointment से शायद ये judgment आई है. नहीं, ऐसा कुछ भी नहीं है. Writ petition was filed in 2015, and the main contention was the uncontrolled power of the executive over the Election Commission of India, and the Supreme Court, well, the petitioners contend the Supreme Court needs to look into this issue, because there is no law that is controlling the appointment of the chief election commissioner and other election commissioners. The appointment of Arun Goyal just triggered this process into almost a fast track state, and, well, delivered a body blow to the union. President के बारे में बात करते हैं. Now president is appointing the chief election commissioner. So Council of Ministers to aid and advise president, that's article 74. We are in part 5 and chapter 1. That is part 5 the union, and chapter 1 will be the executive. Alright, executive extends till about, I think, 77 or 78ish, because Attorney General is 76 and he's a part of the executive. There shall be a council of ministers with the Prime Minister at the head to aid and advise the president, who shall in the exercise of his functions act in accordance with such advice. If the president is acting in accordance with such advice was being tendered by who? The PM. So net if the election commissioners are being appointed by the president, indirectly we can conclude, or by using logical deduction, that they are being appointed by the PM. And if the Election Commission of India is under the control of the Government of India or the Union of India, well then there's a problem, right? To resolve that problem, the Supreme Court has delivered this judgment. Now union, Supreme Court should not intervene. In ये contention थी कि भैया this is purely an executive domain, आप क्यों आ रहे हो यहाँ पर? The court is cannot look into the policies of the executive. The judiciary should remain separate from the executive and legislature. But we remember that's a DPSP under Article 50. We shall try to separate the judiciary from executive as far as possible. In fact, uh, some legal scholars and some proponents of the Union of India, as in the government as well, their criticism is that the doctrine of separation of powers, well, we are not exactly following it. Another story, another debate for another day. All right. So Justice Gogoi and SK Kaul, there was a bench in 2018. They referred it to a 5-member constitutional law bench. So 5-member bench में जो mandate basically था to secure the election commissions of India's independence. ठीक है जी, hopefully अभी तक की कहानी सारी की सारी clear है. Because of those lines, subject to the any other law made by the parliament, law parliament ने कभी बनाया नहीं, तो net president को कौन advise कर रहा था? Mainly the PM. And well, that is what irked the Supreme Court. So अब इन्होंने क्या कहा है कि ऐसा है भाई साहब, यूनियन को कहा, एग्जीक्यूटिव को कहा, इधर आओ, टिल लॉ इज डिसाइडेड, एज एन लॉ इज इनैक्टेड, आपका जो 324 के अंदर जो लॉ लिखा हुआ है उस या तो उसकी एक बेर एक्ट बना दो, एक एक्ट पास करो. टिल देन अ कमिटी which comprises of the prime minister, leader of the opposition. If no such leader of the opposition is there, then well, leader of the party who has the highest numbers in Lok Sabha, and the CJI, they are going to advise the president until parliament enacts a law. Now, of course, the government of India will not like this. The government of India, and in fact, you can very validly criticize the Supreme Court as well, that why is it meddling into the domain of the executive, and the judiciary should remain separate from the executive. I leave those debates and discussions to you. What do you think? Let us have a discussion in the comments down below. Anyway, so 24th November 2022 ko this judgment was reserved, and it was delivered on the 2nd of March, not the 4th of March. 4th of March I am shooting, so I must have written this. Now, Attorney General is R. Venkataramani, just for revision purposes as of today. He was in fact asked, in fact, many things were said to him, ki why such a hurry? Because meanwhile this entire thing was going on, the hearings were going on, and Prashant Bhushan, jo ki petitioner ke, in fact, Arun Baranwal should be also, I think, what was his name? Arun Baranwal, was it? Aman Baranwal or Arun Baranwal? Anoop Baranwal. So Anoop Baranwal, I believe, also should be, is a lawyer only. So meanwhile, so Prashant Bhushan filed for an interim stay and basically didn't want another fresh election commissioner to be appointed because we were very close to the hearing. But the union did not listen, and they approved Arun Goel's appointment within a matter of 12 to 24 hours. And well, the Supreme Court was very angry, and therefore this committee now has been made. But abhi to I think there is no vacancy in the Election Commission of India any which way. Now, I had done a lecture earlier on right to vote, or which right is it, and the story I mentioned to the students that mark it as a legal/statutory right. But now the situation is crystal clear. You need to mark it as a constitutional right, so that जिनको lecture आगे नहीं देखना वो हाँ जी जो mark करना है अपने number उठाए और घर चले गए. But if you really wish to be, or rather really wish to go in depth into law and understand the true position of the right to vote, now the lecture starts for you. And especially for CLAT PG or LLM or Judiciary Pre or UPSC prelims, watch this, because this will now detail out the entire length and breadth of the right to vote. Alright, so we are going to be starting. जो पहला जो case law था, मैं facts के अंदर नहीं जाऊंगा क्योंकि उस lecture के अंदर मैंने काफी सारे facts elucidate करे हुए हैं इन cases के. I will just detail you what was the position of the right to vote in which specific case law. So NP Ponnaswamy versus returning officer Namakkal, right to vote, the Supreme Court held it is a creature of statute, net. They said, well, it's a statutory right. In Jyoti Basu versus Debbie Ghosal, and right to elect is statutory right. Right to be elected also is a statutory right. The Supreme Court pronounced its judgment. Mohanlal Tripathi versus DM Rai Bareli, again they said the right to elect, right to vote is a statutory right. Ramakant Pandey versus Union of India, again the same thing happened, that it's a statutory right. Now what exactly is this? Before proceeding, let us go into the representation of the People Act 951. Section 62 says, उसका title का नाम ही, section का नाम ही right to vote है. तो पहले LLB entrance की किताबों में ये जो यूनिवर्सल सिंगल वगैरह वाली जो आती हैं किताबें, उसमें सब में right to vote कई जगह statutory right mark करा हुआ है इन पुराने question papers in 2008, 2007, etc. Well, because right to vote, well, उस time पे ऐसा ही था, statutory right, because it is given under an act, so it is being created by a statute, so therefore it is a statutory right. But The situation now has completely changed. Alright, statutory rights, section 62, right to vote, is a good section to remember, always should be in your memory for high level law entrances. And section 62 subsection 5 always creates a controversy. It says no person shall vote at any election if he is confined in a prison, so they don't have the right to vote. So legal scholars have also commented, if it is a fundamental right, if it is a constitutional right, well then they should also get this right. So there's always been this right paper confusion hi rahi hai. But now let us try to resolve out the confusion. Section 62 subsection 5 also has been challenged on multiple occasions in different case laws. Now starts the real kahani. If you're watching till now, great, you are a person who wishes to know more and more, and I believe that aims to clear an exam, क्योंकि अभी तक majority जनता जा चुकी होगी. Union of India versus Association of Democratic Reforms 2002 का case law. Right to know information about the candidate was termed as in candidate, the person that you are voting for. So right to know his background, etc., and which include his criminal antecedents. They were included as part of freedom of speech and expression under 19 clause 1 subclause A. 19 clause 1 subclause A is a part of your fundamental rights under part 3 of the constitution, right to freedom basically, and 19(1)A specifically speech and expression. So the Supreme Court said that how does a person express himself by a vote when he doesn't know information about the candidate or the MP, the potential MP or MLA that he's willing to vote for. So therefore it is a fundamental right. The right to know information about a candidate who is fighting for an election. So they labeled it as a fundamental right. Now suddenly Parliament amended it. So the government at that time in 2002, they just straight away went to the Representation of People Act 951 and they inserted section 33A, 33B, which said, 33B said no candidate was liable to furnish any such information despite any judgment of the Supreme Court. A very sort of a 42nd amendment style amendment that they did. This was struck down. So 33B was struck down. Supreme Court कह रहा है भैया ये क्या कर रहे हो, ये तो बहुत बदतमीजी करी तुमने. In PUCL versus Union of India 2003. Alright. So this is a landmark judgment here. PUCL wali versus Union of India. In fact, nota vota bhi jo aapka no other option available also is linked to this these judgments only that we are studying right now, but we won't let us skip those details right now. Then in PUCL versus Union of India, yahi wala. So we are now on the 6th case law. Justice Reddy said right to vote, if not a fundamental right, is certainly a constitutional right under Article 326, and Justice Dharamadhikari also concurred with him. Great work. So now they have completely done a flip-flop. Abhi tak jo position thi कि right to vote the creature of statute hai, it is a statutory right, everything is a statutory right, right to vote as in. So PUCL versus Union of India mein total flip maar diya gaya. Then came the judgment of Kuldeep Nair versus Union of India, in which again a U-turn was taken and right to vote was labeled again as a statutory right. Now what exactly is happening here? Right, so in judgments के बारे में काफी detail में in our old lecture on right to vote करी हुई है, but now I'm updating that. Now this is the lecture that is updating that lecture. Then PUCL versus Union of India, this was 2013 का case, and till this point we have covered in the older lecture as well. This is the second PUCL case in which I think it was a 3-judge bench that said right to vote is a statutory right, not a fundamental right, not a constitutional right. They said this is full and final. It is absolutely full and final. There should be no confusion on it. Great. Now this is the second PUCL case, which basically was connected to Kuldeep Nair. So now we are at today's stage, except for one judgment, we are going to go into that. So in the judgment, in the 378-page judgment, जो Supreme Court ने आज ये अनूप बरनवाला के ऊपर निकाली है, उसके अंदर they referred to the Constituent Assembly debates कि भाई देखते हैं right to vote के बारे में ये लोग करना क्या चाह रहे थे. Because eventually at the end of the day the Supreme Court will interpret the Constitution. The Constitution was written by a Constituent Assembly, and their intent mainly of what they wrote and why they wrote it is given specifically in the Constituent Assembly debates. So they said, well, their intent was certainly to make it a fundamental right after they've referred to a number of debates in the subcommittees on fundamental rights, Dr. Ambedkar's quotes, etc. They said just that they didn't want to offend the princely states, because back then, if we go back when the constitution was being written, it was any which way a nightmarish task to integrate and get the princely states to join the Union of India. Any which way partition was also happening on one side. Bangladesh was being created, etc., etc. A lot many things happening back then. So princely states were any which way very, very reluctant to join, and they were not willing to join, many of them. So not to basically scare them away, not to piss them off, we held, or rather we withheld, the fundamental right to be made as an explicit right under part 3 of the constitution. Because we were still coming from a past in which the poor never really voted, and the poor never really had a right to vote. The marginalized never really had the right to vote. So princely states जहाँ पे नवाब वगैरह थे, they wouldn't really have approved कि भैया सबको right to vote, and you're making it as a fundamental right. So people can even throw us out. So well, to negate this sentiment कि भाई अभी तो इतनी वैसी मुश्किल से ये लोग join हो रहे हैं, और अगर हमने ये लिख दिया, it will be a problem. So therefore, the Constituent Assembly must have not written it as an explicit fundamental right back then. But now the situation is different. So Supreme Court said now we can interpret it as in the manner that we want. Then the Supreme Court went on to Rajbala and others of State of Haryana. That's a 2016 ka case law, in which again, now this is a 2-judge bench. I think it was Chalameshwar ji the yahan pe. And right to vote is a constitutional right. Again, it was again a flip-flop from PUCL second wala, जहाँ पे फिर से statutory right कह दिया था. Now again it has been marked as a constitutional right. And today in Anoop, Baranwal versus Union of India, they have said right to vote. अच्छा, ये discussion इसलिए आई बिकॉज इलेक्शन कमीशन ऑफ इंडिया खुद कह रहा है भाई सब नहीं है, ये तो इलेक्शन कमीशन ऑफ इंडिया के काउंसिल साहब कह रहे हैं कि नहीं है, ये तो नहीं है जी, दिस इज नॉट अ कॉन्स्टिट्यूशनल राइट, दिस इज मेयरली अ स्टैट्यूटरी राइट. हाउ इज द सुप्रीम कोर्ट इवन लुकिंग इनटू दिस मैटर? बिकॉज सुप्रीम कोर्ट की जो रिट जुरिसडिक्शन है दैट इज लिमिटेड टू पार्ट 3 of the constitution. So right to vote now they are saying is a constitutional right. They have just, अभी मैं आपको एक कॉमेडी शो इन्होंने करा है, बट देखते हैं उसके बारे में भी. वी आर फ्री टू क्रिटिसाइज द सुप्रीम कोर्ट. सो रेशियो इज आर्टिकल 326 में चलते हैं. इलेक्शंस टू द हाउस ऑफ द पीपल एंड टू द लेजिस्लेटिव असेंबली ऑफ द स्टेट्स टू बी मेड ऑन द बेसिस ऑफ एडल्ट सफराज. ग्रेट. The elections to the House of the People and the Legislative Assembly of every state shall be based on the basis of adult suffrage. That is to say, every person who is a citizen of India and who is not less than 18 years of age. So anyone above 18, it used to be 21, but by the 61st Amendment, 1988, this age was lowered down to 18. Under any law made by the appropriate legislature and is not otherwise disqualified under this Constitution. Can you be disqualified as a voter under this Constitution? Yes. Grounds are non-residence, unsoundness of mind, crime or corrupt or illegal practice. Under this Constitution or any law made by the appropriate legislature, so Representation of People Act 1951, shall be entitled to be registered as a voter at any such election. So anyone above 18, if they are not disqualified, they get the right to be registered as a voter. And voter वो गंदी सी फोटो खिंचवाने के लिए तो आएगा नहीं ना, वोट करने के लिए आएगा. So that is what their argument is कि भाई right to vote is flowing out from Article 326, and even if it is not a fundamental right, well great, it is certainly a constitutional right. ये आज position अब इन्होंने full and final कर दी है almost. Alright. So full and final अब यहाँ पे इन्होंने last में they just so the majority Ajay Rastogi judge साहब wrote a concurring but a separate opinion. So we have noticed that we cannot and we need not finally pronounce in this aspect. अरे भैया कर देते ना, बात ही खत्म हो जाती. In view of the fact that a constitution bench of this court, which we have noticed in Kuldeep Nair, has proceeded to hold that there is no constitutional right. वो कह रहे हैं हमसे डायरेक्ट तो तुमने राइट टू वोट के बारे में पूछा नहीं, लेकिन चलो फिर भी तुम्हें अच्छी खासी राम कहानी हमने बता दी है, बाकी तुम अच्छे समझदार ही हो और समझ लो कि क्या है. And Justice Chandrachud, CJI Chandrachud, also a couple of days, I think a couple of weeks back, remarked that right to vote certainly is a constitutional right. So you know the inclination of the Supreme Court. अच्छा, रस्तोगी जी ने लिखा कि भैया ऐसा है, आपका जो OHCHR है, that is declared or rather recognizes the right to vote as a fundamental human right. So OHCHR is the Office of the High Commissioner for Human Rights. For current affairs prep, look up who is the High Commissioner today, as of today, for human rights. And रस्तोगी साहब कहते हैं कि 15, 17, 19 and 21 के flow करते हुए read with 326, right to vote, indirect elections, specifically indirect elections, is a fundamental right, subject to the limitations of 326, Article 326 and Section 62, subsection 5. That is what his judgment is saying, but the majority just stopped short of declaring it as full and final a fundamental right or any other thing. But mostly, अब ये इतनी बड़ी राम कहानी हो गई है, तो एग्जाम में क्या मार्क करना है? एग्जाम में मार्क इट एज अ कॉन्स्टिट्यूशनल राइट. अगर वहां पे फंडामेंटल राइट भी हो तो ऑफ कोर्स फिर ऑब्जेक्शन लगानी पड़ेगी, क्योंकि well, now it is a debatable question कि इन जज साहब की बात करें या दूसरे की करें. But certainly आज की डेट में as of 2023 it is certainly not merely a statutory right, alright? क्योंकि even if they have stopped just short of giving a full pronouncement on this aspect, the examiner को इतना ज़्यादा कुछ मतलब इतना ज़्यादा समझाएंगे भी कैसे कि ऑब्जेक्शन उठानी है जी, आप ये कैसे मार्क करा रहे हैं. तो मार्क इट एज अ कॉन्स्टिट्यूशनल राइट, एंड मान लेते हैं वहाँ कॉन्स्टिट्यूशनल राइट कहीं दे ही नहीं रखा और फंडामेंटल राइट दे रखा है, मार्क इट एज दैट. ऑलराइट, तो होपफुली राम कहानी समझ में आई आपको, एंड होपफुली द यू टर्न्स दैट द सुप्रीम कोर्ट हैज एंडलेसली टेकन ऑन राइट टू वोट, दैट आल्सो इज क्लियर. होपफुली द जजमेंट pretty much is clear, the ratio of the judgment, why the judgment was needed, etc. Wishing you all the very best for your exams, whether it's the UPSC, judiciary or LLM, and take very good care of yourself. Study hard. Exams are very, very clearable. Study with focus. Let go of Instagram Reels and YouTube Shorts. This saying no to short form content really helps you out in the higher level examinations. Wishing you folks all the very best. Take care. Bye.